A very good evening, gentlemen. I'm sure we all had quite an awesome and great day. All right, you're welcome to tonight's online session. I still remain your host, O.O. Stevens. And tonight we are going to be looking at the topic, choice of business organizations. Choice of business organizations in corporate law practice. Choice of business organizations in corporate law practice. Now, there are basically two business organizations under the Nigerian corporate law practice. There are basically two business organizations under the Nigerian corporate law practice. We have companies and we have business name. Companies are registered under Part A of CAMA, then business names are registered under Part B of CAMA. And this business name can either be sole proprietorship or partnership. This business name can either be sole proprietorship or partnership. Now we are going to first of all look at what a company is all about and also the features of a company. Please, I want you to note before we go further that what makes a company is that it is established by not less than two persons. Two persons. Company is derived from the word companion. So one person cannot be a companion to him or herself. So it's the presence of another person that makes a company to be a company. So once people are two and above, that is when they can be able to qualify to incorporate a company. Now, what are the features of a company? What are the features of a company? A company has the following features. One is that there is perpetual succession. There is perpetual succession, which means that a company can even outlive the founders, meaning that once a company is incorporated, even the people that founded the company may die and the company will still be living. That is known as perpetual succession. Also, there is limited liability. There is limited liability. A company can either be limited by shares, it can be limited by guarantee, it can even be an unlimited company. Now, there is another feature of a company, which is it has a corporate entity. A company has a corporate entity. This is to the effect that upon incorporation, a company assumes an identity in law that is different from the people that founded it. I hope you have heard about the principle of law in the case of Salmon versus Salmon, which is to the effect that a company takes the status that is different from the status of those that founded or those that established such a company. Another feature of a company is that there is a common seal. There is a common seal. Upon incorporation, a company is expected to have a common seal. It is a common seal of a company that it will be using to be executing any document that it is expected to engage in. Also, the management. The management of a company is highly regulated by the dictates of the law. So the management of a company has to be in accordance with the provisions of the law. Also, when a company is incorporated, it is entitled to availability of funds. Availability of funds means that upon incorporation of a company, it can approach any bank for a loan, and such a bank can easily give a loan to a company because it has gotten incorporated. And in the eyes of the law, a company is seen as a person. So anything that a natural person can lawfully do, a company, which is called a juristic person, can also lawfully do that. All right, what are the types of company that we have? What are the types of company that we have? By the combined reading of section 21, sub 1 and 2 of CAMA, by the combined reading of section 21, sub 1 and 2 of CAMA, there are 6 types of companies. There are 6 types of company, namely, we have private company limited by shares, we have public company limited by shares, we have private company limited by guarantee, we have public company limited by guarantee, we have private unlimited company, and we have public unlimited company. But however, in practice, the above types of companies are not all obtained. In practice, and pursuant to section 29 of CAMA, we have the following 4 types of company. From the ones we outlined earlier, there are 6, but by the provision of section 29 of CAMA and also in practice, what we have is only 4, meaning that we have private company limited by shares. We have private company limited by shares. These are the ones that end with LTD. We have public company limited by shares. These are the ones that end with PLC. We have private company limited by guarantee. These are the ones that end with LTD/GTE. LTD/GTE. And we have private unlimited company. These are the ones that end with UNLTD. Private unlimited company. So we are going to be exhaustively discussing these 4 types of companies and to look at what their features are. Now let us quickly look at the features of an LTD. An LTD is a private company limited by shares. So we are about to look at the features of an LTD. Now it must by its article restrict the transferability of shares. So there is no transfer of shares with respect to an LTD. LTD are private companies limited by shares. Private companies limited by shares end with LTD. So there must be a restriction of the transfer of shares in an LTD. Also, it must have a minimum of 2 members, but the maximum of members is 50. So it cannot exceed 50 members. The minimum is 2, but the maximum is 50. Now, unless authorized by law, a private company shall not invite the public to subscribe to its shares. Unless authorized by law, an LTD cannot invite the members of the public to subscribe to its shares, meaning that LTD cannot offer shares to the public. Also, the name of such a private company must end with LTD. The name of such a private company must end with LTD. And a private company does not keep statutory books like index of members, and it does not also keep register of substantial interest in shares. Substantial interest in shares. So a private company does not have does not keep such a register or such a statutory book. Also, a private company has no restriction in the appointment of a person that is over the age of 70 years as a director. A private company has no restriction for the appointment of a person that is over the age of 70 as a director. And also, the secretary of a private company does not need any special qualification before he or she can be the secretary. And also, a private company can make use of written resolutions in the place of having physical meeting. A private company can have a written resolution in the place of having private meeting where such a resolution will have to be passed. But one thing I would want you to note about written resolution is that before such a resolution can be valid, it has to be signed by all persons. It has to be signed by all persons that are qualified to have attended that meeting, assuming it was called. You know that typically one thing about resolution is that there is what we call ordinary resolution and there is what we call special resolution. An ordinary resolution is by simple majority, so the majority carries the vote. So assuming everybody came for the meeting, assuming we are 10 and 6 voted for something to be done, such resolution will actually be held. But if it is a type that the 10 persons didn't come for meeting and we just drafted the resolution to be passed, now the 10 persons that ought to come for that meeting will all sign before such a resolution would actually be presumed or taken to be passed. That is one thing about written resolution. But written resolution is only applicable for private company. So those and many more are the features of a private company limited by shares. Now, what is the suitability? What is the suitability? In what instance will it be advised for us to incorporate a private company limited by shares? In what instance? Now, where a small or medium-sized business needs to acquire an incorporated status. For instance, if you started small and you are doing something, you and your friend, you guys are doing something little, and you people want to now take it higher, to now incorporate and maybe be seen in the eye of the law as different people from the business that you are going into, but it is still on a very small or medium scale, it can be advised that you go for private company limited by shares. Also, where family members and or friends intend to carry business with an incorporated status and without interference from outsiders, they can go for a private company limited by shares. Also, where the capital available to start the business is relatively small, that is, if it is less than 500,000 naira, if you have maybe something like 20,000, 11,000, because the authorized share capital of a private company limited by shares is 10,000 naira. That is the minimum share capital. So with 10,000 naira, you can incorporate a company that is limited, private company that is limited by shares. All right, let us look at the features of a PLC. PLC is a public company limited by shares. What are the characteristics of a PLC? Now, it can raise money from the public, so the PLC can offer its shares to the public. Also, the minimum number of members for PLC is 2, but there is no limit on its maximum. So the maximum number of members is till infinity. Also, the authorized share capital of a PLC is 500,000. The minimum authorized share capital is 500,000 naira. And I hope you know, without much ado, that both for an LTD and PLC, the authorized minimum share capital must be at all times 25% of it being subscribed to. It must at all times having 25% of it being subscribed to. You can look this up in section 99 of Companies and Allied Matters Act. Also, another feature of a public company is that it can appoint somebody that is above the age of 70, but there has to be a special notice to that effect, and such a person must also disclose his age. So a person that is above the age of 70 can be appointed as a director, but such a person has to disclose his age, and also there has to be a special notice to that effect. Also, the secretary of a public company must be subject to some qualifications. The secretary, before somebody can be a secretary of a public company, the person has to either be a legal practitioner, a chartered accountant, a chartered secretary, or a firm of any of them, a firm of legal practitioners, or a firm of chartered secretaries, or a firm of chartered accountants, before such a person can be the secretary of a public company limited by shares. Also, a public company must hold statutory meeting within 6 months of its incorporation. So statutory meeting is only for public companies. A private company limited by shares cannot hold a statutory meeting. So it's only a public company that can hold a statutory meeting. And its name must always end with a PLC. Its name must always end with a PLC. And you should also note that written resolutions are not actually obtained for public companies. Written resolutions are not obtained for public companies. All right, what are the suitabilities, or what is the suitability? In what instance will it be advised that you incorporate your company as a public company instead of a private company? One of the instances is where a growing medium or large scale business needs to acquire incorporated status. Maybe your business is growing in limbs and in bounds, and you really want to go higher, you can go for a public company. And also where the capital available to start the business is relatively large, that is where it is 500,000 naira and above. Remember that the minimum share capital of a public company is 500,000 naira. The minimum that you have to start it is 500,000. Also, where the business intends to raise capital from the public through invitation for them to subscribe to their shares, then they can register as a public company. Also, where 50 persons and more want to join in the formation of a company. So where more than 50 persons want to form a company, then they can go for a public company. This is because the maximum number of persons that can incorporate a private company is 50. So when the number of people that are interested to so do are above 50, then they unavoidably would be going for a public company. Those and many more are the suitabilities of a public company. Now let us look at the features of a company limited by guarantee. Let's look at the features of a company limited by guarantee. Now, they are not registered with a share capital. That's one of the features. A company limited by guarantee is not registered with a share capital, meaning it has a zero share capital. So, company limited by guarantee is not registered with a share capital. It has a zero share capital. Now, one thing that you also need to note is that the memorandum of a company limited by the memorandum of association of a company limited by guarantee cannot be registered without the consent or the authority of the Attorney General of the Federation. So there has to be the consent or authority of the Attorney General of the Federation before the memorandum of a company limited by guarantee can actually be registered. So you require the consent of the AGF before registering an LTD GTE. Also, the liability of the members is only to the amount which they have undertaken to contribute in the event of winding up, and such cannot be less than 10,000 naira. What we are talking about now is that the liability of members is going to be, because remember from the word guarantee means how much are you guaranteeing that you're going to pay us if this company is about to wind up. So the liability of the members will be with respect to how much they have agreed to pay when the company is about to wind up. And we are now saying now that no matter what any person is agreeing to pay, such will not be less than 10,000 naira. That is it about the liability of members. But remember, there is no share capital for company limited by guarantee. So it is just with respect to what each member has undertaken to contribute in the event of winding up. That is why we call it guarantee. So how much are you guaranteeing that you're going to give us? And also the name of such a company must always end with LTD/GTE. LTD/GTE. And also for company limited by guarantee, there is no automatic right of proxy attendance at general meeting except if it is expressly stated in its articles. Now what we're talking about is for the private company limited by shares and for public company limited by shares. There is automatic right for you to either choose to attend the meeting or not. You can send somebody to represent you. It's automatic right. But if it is with respect to an LTD GTE, which is company limited by guarantee, then the right is not automatic. The articles of association must expressly contain that before such a right can be exercised by the members of the company who don't wish to attend. That is what we call right of proxy. Proxy is that I am not coming in my capacity as O.O. Stevens. I am sending somebody else to represent me. That is what we call attendance by proxy. Now, what is the suitability of an LTD GTE? What is the suitability of an LTD GTE? It promotes commerce, art, science, sports, religion, and charity objects. Maybe if you say anything like sports academy, music academy, all those things can be registered as a company, but it will be a company that is limited by guarantee. Now, it can also be suitable as a subsidiary company set up to render corporate social responsibility obligations for the parent company. So, for instance, now UBA PLC as a bank may choose to have a foundation. They may choose to have a foundation. That foundation they have can be registered as a company that is limited by guarantee. Now, what you also need to note as a feature of company limited by guarantee is that they can do little business, but that particular business they are doing, the gain that is derived therefrom cannot be shared among the members. The profit cannot be shared among the members. But for companies limited by shares, be it public or private, the profit made can be shared among the members. All right, let us look at the features of an unlimited company. Let's look at the features of an unlimited company. It ends with UNLTD. The liability of its members is unlimited. The liability of its members is unlimited. Now, let me explain a little about what we mean by limited by shares and unlimited. For instance, if a company is about to be incorporated, you know that for the private company limited by shares, public company limited by shares, they have what is called share capital. And when somebody subscribes to the shares of the company, meaning that he is taking up a particular number of shares. If you listen to my voice note on the approaches to drafting a memorandum of association, approaches to drafting in corporate law practice, you're going to get to memorandum of association and you will see that there is something we call share capital clause. It means that members, for instance, that the startup share capital of a company is probably 500,000, and a member probably have undertaken to subscribe to 50 shares. That 50 shares he has undertaken to subscribe to means that he is paying for 50 shares. Subscription of shares is not the same thing as paying for shares. Subscription for shares is like I am taking 50 shares that I will pay for. That is subscription. I'm taking 50 shares that I will pay for is called subscription. Now, when you finally pay for that share, it is called pay-in for shares. That shares will now be known as paid-up shares. Now, for instance, now you took 50 shares, that is what you're subscribing to, and probably you paid for 20. That means that you still have 30 that is unpaid for. Now, that 30 that is unpaid for, if the company is about to wind up, the company may call on you to come and pay for that unpaid shares. The unpaid, remember, is 30. It is no longer 50 because you subscribe for 50 but you paid for 20. And there is also something called call on shares. There is something called call on, like in calling on. You are calling on shares. So meaning for people that have not yet paid for their shares, the company can call on them to come and pay for their shares. Such is known as call on shares. So it is not only when a company is about to wind up that you may be required to pay for your shares. There can be an instance where the company can on its own call on you to come and pay for your shares. Now, for the shares that you have not paid for, you are only liable to the extent of those ones that you have not paid for. That is what we are talking about. When we say that the liability of a member is limited by shares, it is limited by the number of shares he has taken. So subscribing for shares is different from paying for shares. So when you subscribe for 50 shares and you have not paid for it, the company will now be calling on you either as a call on share or during winding up to come and pay for that 50 shares. So that is what we mean by that the liability of members is limited by the number of shares that they have taken. Now, why this is like this is because we have already said that the members of a company are different from the company itself. That is why sometimes a company will be dying and the members of the company will be millionaires. So because the company is different from the member, that is exactly what happened in Salmon versus Salmon. So a company may be dying and the members of the company will be driving serious and big cars. So if that company is dying, it's not their business. The only business they have with the company is, assuming they have subscribed to a particular number of shares, that is the only business they have with the company, to come and pay for those shares that they have subscribed to. And assuming they have already paid for the shares earlier and anything is happening to the company, nobody is calling on them. Nobody is calling on them, except maybe there is a requirement for restructuring, maybe for you to forgo some of your alternatives and maybe take up some liabilities, some of your rights and take up some liabilities. Then that is when the company may beg you. It's like a begging because it is your right not to do or to do. That's why you're a member of the company. So your business with the company is only to the extent of the number of shares that you have subscribed, that is, you have taken to pay for. Now, when we talk about unlimited company, meaning that the shares of the company or the liability of members of such a company is unlimited, meaning that if a company is owing 1 million naira, the members of that company will pay the 1 million naira they are owing. So their liability is unlimited. So they are going to pay for everything. They are going to take up the liability of the company as if it is their own liability. So that is the implication of unlimited. So unlimited, nobody is calling on you to come and bring a particular thing that you have subscribed to. No, you are coming to contribute to make sure that this is liquidated. That is what we mean by the liability of the members is unlimited. And it must be incorporated with a share capital. Another feature of unlimited is that it must be incorporated with a share capital. And its name must end with ULTD. Its name must end with ULTD. And the members answer to all claims against the company, especially at winding up. That is what I said earlier. So any claim that any debt the company is owing, the members will pay for it. So in this instance, the members are most often than not seen as different from the company. No, the members are the company. So anything the company is suffering, the members will suffer it. unlike the first two that we discussed, unlike the first two that we discussed, the liability of the members has nothing to do with the liability, the debt of the company has nothing to do with the members. The members are only expected to pay what they have subscribed. So if the company is to die, let it die. But in this instance, no. The debt of the members is the responsibility. The debt of the company is the responsibility of the members. That is it about unlimited company. Now, what is the suitability of an unlimited company? What is the suitability of an unlimited company? Now, where there is an enlarged partnership, which is getting beyond the legal maximum of the members of such a partnership. For instance, in partnership, except it has to do with professional bodies like accountants, like lawyers, it cannot be more than 20 persons. For partnership, we still get there, it cannot be more than 20 persons. So if maybe your partnership is, that partners are like those that are collectively involved both in the success and failure of their partnership. So if partnership wants to now grow in leaps and bounds, and it also want to retain the status of everybody being liable for whatever thing be the liability of the partnership, then they can go into an unlimited company. That is one of the suitabilities. Also, the next suitability is where persons wish to form a company in a manner that will render them liable without limitation for the debt of the company. Without limitation for the debt of the company. So the debt of the company is also their debt, which I have actually said earlier. And also, there are many more suitabilities for an unlimited company. Now let us look at the checklist of the documents that is required to register a company with a share capital. Checklist of the documents required to register companies with share capital. One is that you need to have Form CAC1. Form CAC1 is known as Availability Check and Reservation of Name. Availability Check and Reservation of Name is known as Form CAC1. Availability Check and Reservation of Name. Now we now have Form CAC 1.1. Please, these are the documents that you need in order to register a company with a share capital. Another document is Form CAC 1.1, which is application for registration of company. This form is the form that you use to make application to register a company. And you also have a copy of any identification. A copy of any identification, be it international passport, be it driver's license, be it any type of means of identifying any of the members of the company. It will be needed. And you also need 2 printed copies of memorandum and articles of association duly signed. 2 printed copies of memorandum of association and articles of association duly signed at the Stamp Duties Office of the Federal Inland Revenue Service. So these are the 2 documents that will be signed. Duly stamped, not duly signed, duly stamped at the Stamp Office of the Stamp Duties Office of the Federal Inland Revenue Service. And the next document that you also need are the original receipts of registration fees and stamp duties and compliance oath. And you also need proficiency certificate. This one is where it is applicable. That is where there is an expert that is being a member of the company, and also where the company is into maybe expert-oriented kind of business. There will be a need for proficiency certificate. Also, residence permits, where some directors or members of the company are foreigners, you will need their residence permit. Also, where a minor is a subscriber to the memo, a copy of his birth certificate issued by the National Population Commission will also be among the document. So now, where a corporate body is also a member or a subscriber, you know that a company can be a member of another company. So where a corporate body is a member of this company, then there has to be a board resolution that shows that such a person has been appointed to represent the other company as a member in this particular company. So, and also an affidavit stating where there is an alteration, then there has to be an affidavit stating the fact of such alterations. Now, in all these documents that we have outlined, law school may go further to ask you the documents that have to be stamped Or law school may just ask you the documents that have to be stamped among the documents that will be presented to the CAC to register a company. It's only 3 documents that have to be stamped. The 3 documents are: 1, memorandum of association has to be stamped; 2, articles of association has to be stamped; and 3, Form CAC 1.1 has to be stamped. Form CAC 1.1, I told you earlier, is an application for registration of the company. So that particular form where you make the application and fill the necessary information will also be stamped. Let me come again. The 3 documents that have to be stamped in order to register or in the course of wanting to register a company are: memorandum of association; 2, articles of association; and 3, Form CAC 1.1. So on that, we're going to be drawing the curtain on the concept of business organization, trust of business organization 1. And remember, we are always regulated and modulated by the law school expectations and law school outcomes. Associative reading will not also be bad. But remember, if law school is to set questions, they will not go outside the purview of what we have discussed, because your business with them is on the outcomes that are required of you or expected of you in each of the topics. Do sleep safe and have a healthy night rest.